Alright, we are back at chapter 9 as before. Now we're at paragraph 4. Alright, we have just done the components of the fit and proper criteria test. So we are now at paragraph 4. Now this is a circular on due diligence checks and documentation in respect of the appointment of appointed, provisional and temporary representatives. Right? So here under this circular there are three types of representatives: appointed, provisional and temporary. And this is pursuant to circular number CMI 01/2011. Alright, if you look at the box under 4.1, MAS expects all financial institutions to ensure that the persons whom they employ or appoint to conduct regulated activities on their behalf under the SFA and the FAA are fit and proper. Right? So they are following up with the fit and proper criteria test, the three components. And it says there very specifically, MAS has provided guidance on the fit and proper criteria applicable to the appointment of these three types of representatives under the Representative Notification Framework, the RNF. Right? We have discussed in some detail regarding the RNF in the earlier chapters. Earlier, I think 2 or 3 chapters that were mentioned about the RNF. Right? So financial advisors may have their own internal recruitment criteria, which may impose specific or even more stringent criteria than those stated in the guidelines. Now, this particular circular provides further guidance to assist financial institutions in their conduct of due diligence checks and documentation relevant to the fit and proper certification of representatives. Right? So you need to certify that they are fit and proper under the RNF. I hope you remember that as well. All right, there's a lodgement of intent and lodgement of certificate, etc. Now, the guidance, which is based on the consolidation of the industry's good practices observed by MAS, sets out MAS expectation of the checks, the due diligence checks that should be conducted to the extent practical and applicable, and is not intended to be exhaustive. Right? So clearly MAS tells the financial institutions, right, that what has been provided in the circular is not exhaustive. Right? And the bigger the financial institution is, with worldwide branches or subsidiaries or representative offices, right, then you need a greater reach, as it were, and higher standards in applying these due diligence checks on the people hired by the financial institutions. Right, now fit and proper declaration. Right, now this is something which the FIs, the financial institutions, need to look at. The board and senior management, right, are responsible for putting in place clearly defined and documented policies and procedures, right, to ensure that it recruits and retains only a fit and proper person as an appointed, provisional or temporary representatives. Right? Now, these expectations are set out in this particular circular. Right? Right, just to repeat, put in place clearly defined and documented policies and procedures. Right? In fact, this should be in the handbook. Right? When the financial institution hire people, right, to set out what is required under the guideline, right? Or at least during the induction period or the initiation period, to make sure that the employees continue to conduct themselves in a fit and proper manner. Right? At the point of hiring, of course, the financial institutions have done all the checks, and if these people should come on board, then there should be frequent reminders to ensure that they continue to be fit and proper persons, and to give them some guidelines, as we have discussed earlier under paragraph 3, so that they remain honest, have integrity, and maintain a good reputation. All right, so they are competent and capable, meaning attend regular training courses, update their skills and knowledge in the relevant practices, and importantly, update themselves on the rules and regulations governing their respective practices. Right? So that is quite key to ensure the continuity of these representatives being fit and proper. All right. So the entry point is important to make sure that the financial institution engage the people that are fit and proper. But having brought them on board, there must be this continuing reminder that these people should continue to be fit and proper. All right. Apart from that, apart from the declaration that's required, this can be found in Annex 1 of the circular. All right. So you may wish to refer to Annex 1 to look at MAS expectations in respect of the declaration. Now moving forward, look at paragraph 4. Then again it says due diligence checks. Right? Now MAS expects financial institutions to conduct rigorous and independent checks on the fitness and propriety of the representatives. Right? The due diligence checks which the FI should conduct are set out in Annex 2 of this particular circular. Alright, so there's an Annex 1, there's an Annex 2, so take a look at that one in order to be able to find out what kind of checks are required in relation to the MAS. Okay? Alright, now paragraph 5, very quickly, we look at continuing education. Now this is to ensure competence and capability. Right? The third line there says to keep abreast of developments in industry and update skills and knowledge relevant to the businesses, the activities, or the practices that they conduct. Financial institutions must ensure that its representatives receive adequate training, right, knowledge and skills, as I've mentioned, either under the SFA, the Securities and Futures Act, or under the Financial Advisors Act. Now, the details are set out there for you. And paragraph 7 talks about the quality of training. Right, they should be well structured and go beyond, underline that one, go beyond satisfying requirements on training hours. Like I said earlier to you, financial advisor representatives just go for the training, just to chalk up the training hours. All right, that should not be the case. All right, well, that is necessary and mandatory. The attitude, right, and the attitude essentially must go beyond that. Right. And the FA has a responsibility to ensure, to satisfy that the training is adequate. All right, and the representatives are properly trained, and that should be documented as well. So in this regard, as I was telling you earlier, in the earlier chapters, the test ought to be provided, right, to test whether the trainee or the financial advisor representative really understand what has been taught. Right? It is easy to set through a 3-hour program or a 5-hour program, but at the end of the day, if the financial advisor representative goes away with nothing, just getting the CPT hours, then that may not be satisfactory. All right? So the financial institution must be satisfied that the training is adequate and really the financial advisor representative learns something from it. Or either to a formal assessment test or in practice, right? If there's any shortfall, then it must be pointed out to the financial advisor representative that, hey, look, that is a gap in your training. This is demonstrated in your practice, in the way you are doing things, and therefore you need to go for that competency training in regard to competence and capability. All right, that covers the continuing education part in terms of doing the necessary due diligence in respect of the 3 types of representatives. Right? Now, 8 talks about conflicts assessment. Now, the financial institutions should be cognizant of, all right, should be aware of, all right. Cognizant means to be aware, to be in the know, and ensure that there are no conflict of interest in the representative's personal circumstances, all right. Relationship with connected persons, other businesses, partnerships, sole proprietorship, etc., directorships, or work arrangement within the organization that will impair, all right, that will impair the representative's ability to discharge the fair dealing responsibilities of a representative, as the case may be, whether he is or she is an appointed provisional or a temporary representative. All right. So make sure there's no conflict of interest situation, right? So in terms of this person's standing with regard to other connected persons or work arrangements, right? So that there could be conflict sometimes when, I'll just give an example, a husband and wife working in the same department, that could be a conflict of interest, right? Or a person working in the department and the financial institution has a relationship, a business relationship with a company. Okay, financial institution has a relationship with a company, and the representative, right, has some shareholdings in the company between the financial institution and the company. All right, so that could be conflict of interest, where the representative holds shares or shareholdings or immediate family, right, of a company that has dealings with the financial institution. So that could be conflict of interest, right? So it may impair or affect the representative's judgment, right, in discharging the responsibilities on behalf of the financial institution. All right, because as an employee, there is this relationship, all right, to work for the best interest of the financial institution, rather than for some other connected person, which is which is a customer of this financial institution. Okay? Now, paragraph 9 gives you some details that some regulated activities of financial advisory services may give rise to conflicts. Example, dealing in capital market products that are securities, execution only, and corporate financial advice. So there could be conflict in the dual role. Right? Potential conflicts with representatives' proposed regulated activities of financial advisory services can also arise as a result of this shareholdings or business interests, right, or other roles with the company. Right? So as I mentioned, I'll give you some other examples of it. So that relates to the issue of conflict of interest. Now, paragraph 10 provides that the FIs should assess such conflicts. You must be cognizant or cognizant of the conflicts, right? And then you should have the proper mitigating measures, all right, to address them. I mean, conflicts do exist from time to time, where such measures are not plausible, without compromising the representative's ability to discharge his duties and responsibilities and comply with the regulatory requirements. Then the FI should not, underline, should not proceed to appoint that individual as a representative, right? Whether appointed, provisional, or temporary, right? And you look at the footnote below, the subscript below, you can see the individual should truthfully disclose his business interests in other entities in Singapore, all right? So this individual, as I said earlier, may have shareholdings, or maybe a son or a daughter, you know, of the beneficial owner of the company that the financial institution has a business relation with, either in Singapore or overseas to the principal, right? So these individuals must on its own inform the financial institution that, look, I'm such a person, and if I perform this role in relation to that company, then there is going to be a conflict of interest. Right? And this information is required to be provided to the MAS for its appointment as the appointed provisional or temp representative, as the case may be. So this is part of the due diligence check in terms of the circular CM101/2011. All right. Now just to backtrack a little bit, so fit and proper declaration, due diligence checks, continuing education, and then conflicts assessment. All right. So up to now, these are the due diligence checks that the financial institution is required to do, all right, or should do under this particular circular. Now, then moving down at 4.2, right, 4.2. Here it sets out the fit and proper declaration that we have talked about earlier. And you can see under paragraph 1, it gives you the same standards, the same components of the proper fit and proper criteria test, right? So here it states it's not limited to the following. All right, so not limited to the following in terms of the declaration, right? The fit and proper declaration. All right. So again, the same three components. All right. A, B, and C, i.e., honesty, integrity, reputation. 1. Right. 2, competency and capability, and 3, financial soundness. These same components, the same three components, go across the board. Okay. Now, 2 is a bit new, so please take note. A financial institution should obtain and maintain written self-declaration. Underline the word self. These are the self-declarations from its proposed appointed provisional or temporary representative. That this particular representative has read and understood the guidelines, and he satisfies all the criteria. All right. So this is something new. All right. Apart from what we have discussed, something new from what we have discussed earlier in terms of the guideline on the fit and proper criteria. Now there's a further requirement in terms of the fit and proper declaration. All right, this is a declaration, right? A written self-declaration from the representative. All right, so this representative says that, look, I have read, I have understood the guideline, and I satisfy all the criteria. Right? Now, to draw attention to the fit and proper criteria in the guidelines, the FI is encouraged to include in the declaration form such relevant questions as are set out under the details of self-declaration at the end of this annex. All right. So here the circular here provides the details of self-declaration. Right. It's a long list there. You will see later on, a very long list. And this representative, whether appointed, provisional, or temporary, has to make this self-declaration. All right. Now, 3 is it's again very specific, a further guideline. In addition, the FI may wish to consider including in the written self-declaration, underline this one, a confirmation from the proposed representative that he is aware that under Section 990 of the SFA, the Securities and Futures Act, Section 990 of the SFA, and Section 23L, L for London, Section 23L of the FAA, the Financial Advisors Act, an individual who has provided a statement that is false or misleading in a material particular to his principal, that means his the financial advisor or the financial institution, as the case may be, and which statement is subsequently lodged with the MAS. Now you remember that the financial advisor has to lodge the statement with the MAS, or has omitted to give information to his principal. All right, principal, as I said earlier, meaning the financial advisor or the financial institution, which causes the lodged document to be misleading in a material aspect, shall be guilty of an offence and shall be liable on conviction to a fine not exceeding $50,000. All right, what does all this mean? All right, it means apart from the written self-declaration, all right, the FI may wish to consider in a written self-declaration a confirmation from this representative, this proposed representative, that he knows about the penalty, right, of not more than $50,000 if this proposed representative is provide a statement that is false or misleading, all right, to the principal. Right, so this is a double kind of security in terms of making sure that the proposed representative is a fit and proper person. So that person has to declare and has to confirm that he understands what he has declared. All right, if he has declared wrongly, in a misleading way or in a false way, then the proposed representative is fully aware that he could be fined up to $50,000 upon conviction. Paragraph 4 says, where the proposed representative has indicated any adverse information in the self-declaration form. Right? As you can see later on, the details are a lot. All right, there are a lot of details there in terms of the self-declaration, And in the event that the proposed representative has indicated something that's adverse, all right, something not in his favor, then the financial institution or the financial advisor should obtain details of such adverse information from him or her, all right? And if the financial institution should appoint this person, then it must give reasons for it, right? And it must maintain proper records of these reasons, right? So the financial institution must have reasons, good reasons to employ this person despite the adverse information in the self-declaration, and to maintain the written records as to the reason why this financial institution assesses that particular proposed representative to be a fit and proper person. All right, and if that be the case, then where appropriate, the financial institution should put such individuals under close monitoring or close supervision for an appropriate period. All right. So the circular provides an avenue, all right, for a proposed representative that has contravened or that has been self-declared as having contravened some of the details under the fit and proper criteria, under the three components of the fit and proper criteria, and notwithstanding that, if the FI, the financial institution, wishes to hire this person, then the FI must give reason and document the reason why. And thereafter, upon employment, then to provide close monitoring and supervision of this person's business conduct. All right. So paragraph says self-declaration by a proposed representative constitute a necessary. All right. It is necessary, but it is not sufficient. Right. Measure in the FI's due diligence on the individual's fitness and propriety. Yeah, the self-declaration is one thing. It is necessary as provided or as guided by this particular circular, and also by the notice on fit and proper criteria. So necessary but not sufficient, right? In addition, the FI to obtain written and fit proper to endeavor to do the following. All right. Apart from all that, you should do more. The FI, the financial institution, to do more. And what is the additional things to do? So paragraph 5A says, verify relevant documents from the proposed representative in support of his fit and proper declaration. All right. So self-declaration is one thing. All right. Then you got to verify the relevant documents. All right. So if this proposed representative say he has a certain qualification, right, and therefore you must verify verify with document. All right, that this proposed person really has the certificates to prove that he has obtained such qualifications, right? And here it gives specific detail, right? Like professional certificate, printed results of the applicable capital markets and financial advisory exam, the CMFAS exam. All right, if this person has passed module 5 or whatever regulatory module, then this person must be able to furnish to the financial institution the relevant documents, right, to prove that he has passed module 5 or whichever module. All right, or if you say that he is a CFA, then he must furnish a certified true copy of his qualification as a CFA, or whatever qualifications that proposed representative may have. Okay? Right, that's under 5A, verify relevant documents. Right. 5B says conduct independent due diligence check to ensure that the proposed representative satisfy the fit and proper requirements. Right. This is a very common thing, and the footnote there too. This should include checks to ascertain that the individual is neither suspected of nor involved in money laundering or terrorist financing activities. All right. Do a name check on this particular person. All right, on the relevant website, right, on the relevant checks to see whether the name pops out, to say whether this particular proposed representative is involved or suspected of money laundering or terrorism financing. Okay? Then, of course, paragraph C talks about maintain adequate documentation, right, so that you have relevant checks and assessments in relation to this. So the onus is on the financial institution, right? So these are the additional things that the circular requires. Okay, so if the proposed representative has indicated any adverse information on himself or herself in the self-declaration, or if the financial institution from its own checks and investigations and so on has any adverse information on the individual, right? Any misconduct, right? And the FI should accordingly declare under the fit and proper certification. Remember, they need to lodge a certificate section of the representative notification to the MAS, right? That the financial institution is aware and has assessed the individuals as adverse information and find it okay, as it were, to hire this particular person, like under paragraph 4 of Annex 1. Okay. Right. Now we move into the details of the self-declaration form. Now you will notice that, as I've said earlier, a lot of details on that one. All right. Paragraph 7 says, again, it's not exhaustive. Below are some questions relevant to whether the person is fit and proper, and the financial institutions are encouraged to include in the self-declaration form. All right. Now I've seen this myself, and I've filled in some of these forms. This declaration when I did some work for certain institutions, right? So it is a minefield out there. It's a long list. Maybe I just run through very quickly in a sampling kind of way. You look at the first sentence there in terms of honesty, integrity, and reputation. Now, within the past 10 years, all right, so it's a long time. Over the last decade, all right, has the individual A, right, similar like what we have said before, refused the right or restricted in his right to carry on any trade, business, profession, where license or registration